If your name is Shah Diddy, it looks like you're trying to put in a motion that you think will save you from going to jail. Everybody is looking for motions to dismiss, and Diddy has put forward a new motion that Justin, Quincy and Christian are hoping will be the straw that breaks the camel's back. If you guys don't know, Diddy is engaging in very high-stakes legal maneuvering. I'll say this, Marco Giuliani woke up, and Marco Giuliani woke up, and Marco Giuliani actually clocked in. They're doing a risky legal gamble, one that could have a huge payoff for Diddy. Let's get into this. Now, if you guys don't know, of course there was a letter submitted to the court. Diddy is still saying that there are investigators in Virginia who he thinks are leaking evidence to the feds. Now, let me just tell you this. I don't think there's any truth in this. I mean, it might be, but I just don't think so. I think Diddy is throwing red herrings at the court because he's trying to run out the clock. It seems like the feds have realized that, and they submitted their own message to the court. We're going to get into what it means, we're going to decode it, and we're going to get to the bottom of it. This was a letter submitted by the prosecution. I'll try to go live later and read the whole letter, but let me give you guys a rundown of what it said. The prosecution is pushing for earlier pre-trial disclosures, but Diddy is arguing that the current timeline is already tight and sufficient. Now, this makes no sense because the key point is this. This is a high-stakes battle, and it centers on the delicate balance between Diddy's right to a fair trial and the prosecution's preparatory needs. In this pre-trial motion, the government wants the deadlines moved up 2 weeks. They're saying the current timelines don't allow for enough preparation. They're arguing that they should follow rulings on pre-trial motions to avoid inefficiency. Now, here's what you can say. The prosecution appears to be playing hardball. However, the defense is hoping that the prosecution is actually overwhelmed by the scope of the case. The defense says they don't want any changes to the timeline. The timeline is when everything's supposed to be produced, citing a heavy workload and the need to suppress evidence from unlawful searches. Now, let's go back to those unlawful searches, because now, and I see that all these things are like, oh, it was a masked man, it was someone in Virginia. You guys just need to listen to me. I believe this is nothing but a stalling tactic to run out the clock. Why? Well, listen to this. Let's get back into this. Diddy's team is also arguing that early trial disclosures won't harm the government but will help ensure a fair trial. Now, what do they want to be disclosed early? They're saying that the prosecution hasn't clarified who they view as victims, and this leaves the defense unable to prepare efficiently. Now, Marco Giuliani, he's painting himself as an underdog, and it looks like they're also trying to set up for an appeal if things don't go their way. Now, interestingly enough, and it needs to be said, they're setting up for an appeal. Did Diddy? Okay, I guess Marco Giulio needs another summer beach house off the coast of France. That appeal is in. Okay, now here's the point of contention. There's something called an enterprise letter. The enterprise letter is going to detail the racketeering charges. The prosecution is saying, hey, can we have until March 7th to align with rulings on the pre-trial motions? Why is that so important? Because the pre-trial motions are basically about what evidence can be used in court or not. The prosecution will waste a lot of time, money and man-hours building a case on things that will eventually be dismissed. The defense is like, no, you've got to stick to February 1st, 2025, because it needs to allow us adequate time to prepare for trial. They also want expert witness disclosures. There is a debate over simultaneous versus staggered disclosures. The prosecution prefers efficiency. They want to say, listen, when we get to that bridge, we'll give you all the information. The defense is like, no, we want you to give it to us as you discover it. This is a way of short-circuiting the prosecution's case. Again, there is a power play happening. The defense claims the government's withholding strategy undermines the fairness of the trial. You could argue that this is maybe having your cake and eating it too, because the prosecution brings up a point I'm sure a lot of you are thinking. Okay, so Diddy's team is rushing to trial but demanding extended preparation timelines. Now this is a classic legal chess move, one that I hope the judge can see through. The defense is claiming that Diddy still doesn't know who all the victims are. Somebody tell Marco Giulio the victims are whoever Diddy talked to, worked with, or passed a Diet Welch's grape soda to, right? Again, they're worried that there's going to be surprise evidence or mystery witnesses. But you get the point. The prosecution is saying, Your Honor, Diddy is the one rushing for a shortened timeline, but now you're saying we need to move all the deadlines up to accommodate your rush, but you don't want to speed up? You can't have it both ways. You know what I'm saying. So these are the big questions. Is the defense using this timeline to stall for time? I believe so. They're hoping that the prosecution is overburdened and that they won't be able to build a good case in time. If they basically slow them down with all these pre-trial motions, the prosecution will be overburdened with the case and won't have time to bring up all these charges. However, I believe the prosecution is strategically withholding information. Listen, these power dynamics and aggressive deadlines are saying a lot. Now, getting back into the prosecutor's concerns, because I feel like we actually need to talk about this. The prosecution is arguing that the current schedule doesn't leave enough time. Let me know what you think in the comments. The prosecution is arguing that the current schedule doesn't leave enough time to address critical pre-trial motions before the trial begins on May 5th. They fear that unresolved pre-trial motions, like challenges to evidence or charges, could disrupt their trial preparation. They believe the pre-trial motions will shape the trial's scope, including what evidence and charges are admissible. Now, without early resolution, the prosecution might well waste time preparing for issues that could later be excluded or altered by court rulings. The trial disclosures, everybody's arguing for these, include evidence details, witness lists, and expert notices. The prosecution doesn't want to submit this information before pre-trial motions are decided because rulings could change what they're allowed to present. They are heavily emphasizing that the schedule proposed by Diddy deviates from what is considered normal in this district, where such timelines are typically shorter. Again, there's a strategic advantage by resolving pre-trial motions earlier. The prosecution can refine its case strategy and avoid inefficiency. After all, remember I said the law promises speediness and efficiency, right? They don't want to commit to trial disclosures like detailed charges or expert testimony, only to have them revised at pre-trial rulings. With that tight timeline, the May 5, 2025 trial date is quickly approaching. The prosecution feels the clock is ticking, especially since discovery or evidence sharing was only recently completed. Now again, let me know what you think. Diddy is pushing back hard against any changes to the timeline, saying they're already overwhelmed with the amount of discovery, but you're the ones that asked for it. You knew what you were getting into, saying thousands of pages of evidence. Rushing a timeline will prevent them from preparing critical motions, like those challenging evidence obtained through unlawful means. Over-reflectively, he concludes by saying, search warrants an early trial. Disclosures won't harm the prosecution, but are necessary to ensure fairness. Okay, again, this is a lot. Do you think that the Diddy team is going to be successful in this? I don't think so, because you guys are the ones rushing this, but then you want to slow things down again. We are seeing from the Diddy trial and the Jay-Z's trial, yes, the law is about justice, but it's also a carefully orchestrated dance, and one that if you do not know the moves and quickly find yourself X out is a game of musical chairs, one that every time the music stops and the music stops, and every motion you can find yourself disadvantaged and out on the room again. Listen, I don't know the disc overload. That's what Diddy asks for, that you need time to review. If you need time to review, then move the trial date. You can't say that you're mad that they gave you a mountain of evidence that you asked for and demanded, but you don't have time to review it, but you want to review it, but not before the pre-trial motions. Again, you're hoping that the prosecution is overburdened and not DD class, again, the dismiss of charges, that's not going to happen. The suppression of evidence, they're working hard to do. And listen, the Diddy is also claiming he doesn't even fully understand the prosecution's allegations yet, including who the victims are and what the evidence will be used, and the enterprise level would help clarify the prosecution's case. Let me just say this right, Mark Aguilera is actually working, and this is what Diddy is paying these lawyers to do. This is what he is paying these lawyers for. Again, how do you think this is going to play out? Right, without enough time, Diddy's motions might, like death, will fail to address all relevant issues in a review of discovery, could lead to missing key pieces of evidence. Is also that thing that there will be reduced negotiation leverage. Strong pre-motions can pressure the prosecution again, right, to drop charges or agree to favourable place deals. Say rush defence might lose this leverage, and also appeal risks the rush trial. Preparation could lay the groundwork for an APE pill if the defense can argue they were denied adequate time to prepare. However, the strategy is risky as the pills are difficult in time consuming. You guys, what do you think about all this? I think that Diddy is playing a risky legal game. I think it is one that he will most likely lose. I think Mark Agnifilo Donna, he is Finn and clocked into work, and Mark Kimberly is doing the things that did he originally paid him a small fortune in gold, blood, sweat and tears to actually bring forth to all the court. However, it's very, very risky. But at this point, Diddy don't got nothing else to lose either. I mean, I'm just saying, through everything. And the kitchen sink as it anyway. You guys, let me know what you think in the comments. I'm going to try to go live later to explain this in even more detail. But yeah, it is on this judge's ruling, I think, is going to set the tone to how many swathing indictments Diddy will actually get. Again, law is the game, and it looks like Mark Hamill is playing it. Well, how? At the end of the day, come on. You can only put so much lipstick on the pig wipe. You can only put so much lipstick on the pig. Anyway, y'all, let me know what you think in the comments. I'll talk to you later. Bye.